Good morning, and I appreciate all y'all coming out this morning. I've tried to make it, a lot of you guys I've met before, and the ones I haven't, it's been a pleasure to meet you today, and I look forward to meeting the one or two that I haven't met yet in a little bit. I want to take the opportunity, because part of what we do this for is to explain our firm to groups that we meet. Our firm, Matthews, Jones, and Hawkins, is based in Destin, but we have offices in Walton County and Funiac Springs and in Niceville, Florida. And we're excited about that because, unlike a lot of firms, we have 12 lawyers, all of whom are actually members of the firm. And the equity partners have made the commitment to this community to establish these offices in Funiac, but we were able to bring in a gentleman a lot of you probably know, Mark Davis, who's been in the community for a long time, served on the school board, so over 25 years experience and really a great guy. So for the Funiac needs, he's there. And we were really fortunate to get Mike Jones in Niceville, who's been a member of that community for 25 years, to be a part of our firm. So we're excited to have that kind of experience that's available to this community, no matter where you might be located in the Emerald Coast. I mentioned that we have 12 lawyers. These lawyers, very few firms, in fact, there's no firm that has offices in Walton County that are the same size as we are. And it's not just because we want to be big, it's because we want to bring a level of expertise in specialized areas to meet your individual needs. We also take a holistic approach in how we deal with client representation, which means we really try to figure out how the big picture for each person is going to work out. And unfortunately, or whatever the case may be, the economy has presented us with the challenge of advising clients about the topic that we're going to speak about today. As you all know, having been in this community for a good while, during the boom days of real estate, this was the last thing that anybody talked about or thought about or planned for, which was actually the best time to be talking about it and planning for it. But the topic of how to keep what you got when the wolves are at the door is one of those catchphrases that really talks about asset structure and asset protection. What assets in the state of Florida, which is an incredibly friendly debtor state, by the way, are available to you to kind of marshal yourself and structure yourself so that, heaven forbid, some terrible event happens, whether it's an aggressive bank loan that goes bad, or whether you are faced with a tort claim, or whatever the situation may be, you may be dealing with this. So, next. How about that?
Did you have a page down, John?
I do. Well, actually, there's too many arrows on this for somebody that's as technologically challenged as me. I'm proud to have today my partner for going on 14 years now, Dana Matthews, and I'm John Hawkins, as I explained. Let's talk about general concepts. And the concepts are, what can you do to risk manage unavoidable or potentially catastrophic circumstances? The first thing is, have ample insurance. For those of you that are insurance agents, you're loving me right now, but ample insurance is critical to manage your liability. And that comes in several forms. Y'all know about homeowners insurance. You know that there's specific risk insurance for different types of matters. Commercial general liability insurance if you have an office. But there's also umbrella policies which take into consideration all these underlying policies and rate premiums and risk on those policies, and can provide you with significant protection at a fairly nominal cost. So I would encourage you to get in touch with your insurance agent, your property and casualty guy or gal, and tell them about what your needs might be for an umbrella policy. And I would recommend a minimum umbrella policy. The umbrella concept being that after your other insurance is exhausted, this insurance kicks in. A minimum amount of $1 million for liability. Bankruptcy relief isn't what it once was. There was a significant legislative change in the bankruptcy rules. I am not a bankruptcy lawyer. I know just enough about it to tell you that if you are ever in that position, you need to consult with bankruptcy counsel. But what I will tell you is that the one super creditor that you do not want to have chasing your tail is the United States government. And that can come in many forms, as Luke will tell you, whether it's the Internal Revenue Service, or which he can help you with, or whether it's all different kinds of circumstances. Bankruptcy trustee representing the United States interests, and they can claw in assets that a normal creditor can't claw in and have look-back periods that are extensive. So the third thing that you can do, not looking at bankruptcy as really as an alternative to preserve assets is the important concept, is to maximize your exemptions. And we're going to go through and discuss various statutory and constitutional exemptions in the state of Florida for assets. So the target would be risk management with insurance, plan with your assets to go for the exempt categories, and when hard times come, you don't rely on those exempt categories to meet your ongoing cash flow needs. You rely on everything else, so you protect what you can at the end of the day. If you can't exempt an asset, place the asset in a structure where ownership is statutorily protected. There are many different forms of business ownership, not only in the state of Florida, but across the states. And each state has its own rules. In Florida, we've got some favorable rules. There are other states that have favorable rules for creating an entity. All y'all probably are small business owners, and y'all have taken the opportunity, most likely, to operate instead of a sole proprietorship in a form of limited liability entity, such as a C corporation, which is a standard corporation, an S corporation, which is a tax flow through entity that gives you the same tax attributes of a partnership, but the protection of a corporation in terms of limiting your liability. And of course, the limited liability company, which has been a very popular tool over the last several years. I see everybody taking notes, and I encourage you to do that, but there will be handouts. Everything that you see today, there'll be a handout for you, including the statutory backout, so I don't want you to fret if you miss something that you perceive as important, because we will have handouts for you. So the general concept about liability protection is, if you're a general partner, or if you are a sole proprietor, or that type of person, you're going to have full liability for any acts of the entity. Not a good idea. What you want to have is a corporation or limited liability company that limits your liability to the investment that you've made in that entity. In other words, if I have a business and I have commercial general liability insurance and I don't operate it as a corporation, and I also have 3 lots that are paid for down the street worth $100,000 apiece, and heaven forbid some tragic accident takes place on my business premises and I'm not a corporation, then that person is going to have recourse against me as the proprietor, and including the ability to attach my paid for lots over there. Contrast that if I have a corporation and that business operates in itself, and I've invested $100,000 in that business. I could lose the entire value of that business if the liability exceeds what the insurance coverage provides. But those lots that I have in my individual name, I'm treated as a shareholder, and I am not going to be subject to liability for those liabilities. The Exxon Valdez would be a great example. When that ship went down, you didn't see Exxon shareholders pulling out their checkbooks and writing checks to cover that problem. They lost value in stock, which of course they've recovered many times over since then, but they did not lose their individual assets. There's no better state in the country for a debtor to be domiciled than Florida. And why are we trying to do all these things? Well, there is a statutory provision called the Uniform Fraudulent Transfer Act, and there's a version of that in almost all the 50 states. And here's what it's trying to avoid. That I get sued, I get a judgment, and the day after my judgment, I transfer all the assets that were in my name without consideration to my brother. He doesn't pay me anything for them, I just give it away. That's the general concept they're trying to prevent against. And what it deals with are claims And this is the statutory definition of a claim: a right to a payment, whether or not it's reduced to a judgment, whether it's liquidated, which means defined, or unliquidated, we don't know what the value of it is yet, whether it's fixed, whether it's contingent, whether it's matured, unmatured, disputed, undisputed, legal, equitable, secured, or unsecured. That's a lot of different things that can be a claim. Okay, so it's a very broad-based concept of what a claim is. The transfer is fraudulent whether the creditor's claim arose before or after the obligation was incurred. What does that mean? That means that if I intend to defraud it, to hinder, delay, or defraud any creditor, and I structure myself with that specific purpose in mind, and that's the only purpose that I'm doing it for, then even if I don't have a creditor at the time I structure that, that creditor could make the argument that I intended to defraud them by structuring myself in that way. So this is a very, very powerful statute. Fortunately, there's a lot of other reasons that you structure assets. Limited liability protection that's available with the corporation is an okay reason to do that. You can have estate planning purposes that you would be structuring things. And planning for retirement. One of the exempt assets that we're going to talk about is retirement funds. They're exempt. Well, you're not planning to put money into the retirement fund to protect them from assets. It's just a byproduct of that, and a wonderful byproduct. Okay, the final thing, and this is important, that you don't receive fair market value, reasonably equivalent value in exchange for the transfer, and that the remaining assets are unreasonably small in relation to the transaction, and that the debtor, in my example, me, would have believed that that I wouldn't be incurring debts beyond my ability to pay. So, fair market value on that transaction I was just talking about. Instead of giving my brother all my assets, I sell it to him at a fair market value. Okay? Well, all I've done really is I've gotten a bargain for exchange. I've got money or a promissory note or something of value instead of what I had previously. That still could be attached by my creditor. So that wouldn't be a fraudulent transfer. It also wouldn't be very effective for asset protection.
Because it's oftentimes as a lawyer you get involved in these cases, you know, when something's happened. And I'm going to give you a couple examples. These are all public record. I'm not going to give you names, but these are public record, real life cases dealing with this particular statute that we're talking about, the fraudulent conveyance statute. It hasn't been well utilized by the lawyers in our area, but it has been in some particular cases. It's very difficult because the key to the statutory scheme is, did you intend to defraud, hinder, delay, avoid? Well, you're not going to testify. Oh, yeah, I agree. That's exactly what I was trying to do. You ain't going to testify that. Because so what happens is in courts, I mean, as you know, if any of y'all been in litigation or read about it, you have depositions, you have interrogatories, you have different discovery tools where they can try to ferret out what's in your mind, what would you intend to do with a particular document, etc. They can interview your lawyers, what have you. In a particular case, you have a guy who and wife have been married 35 years. They have substantial real estate assets in several counties that are all unencumbered real estate. Old country boy, grew up in this area all his life, him and his wife, everything's going to be in his name. That's just the way it's going to be. And not thinking about anything like could happen that we're about to talk about. He gets involved in an automobile accident, and allegations are that he was at fault, and somebody is killed, and a child, and that child's mama was hurt, and the brother was hurt, and all of a sudden there's a lawsuit filed, of course, for wrongful death and under the negligent statutes against this guy. Before this guy gets sued, but he knew that the accident occurred. This husband and wife had ostensibly been having trouble for a long time, and this was an opportune time for her to get out from under the yoke of her husband. And they went and had a divorce. And they both got divorce lawyers, and those lawyers worked it out. But it happened over a quick period of time, over a 6-week period of time. And they get a divorce, and during that divorce, she gets half the assets. He has to convey over, write quick claim deed over to her for half these real estate assets. He retained certain interests, she got certain monies, etc. She waived her alimony in exchange for an unequal distribution of the real estate assets. And then after that occurred, then the lawsuit gets filed. Well, after the lawsuit gets filed, the lawyers for representing the plaintiffs realized that by doing public record search that there had been this asset transfer. They amended their lawsuit, and now they bring her into the lawsuit. She wasn't on the title of the car. She wasn't the vehicle that was involved in the accident. She wasn't the driver of the vehicle. Now she gets sued with him, and now besides the negligence and the wrongful death parts of the claims, now they're asking for damages and to set aside all these transfers, claiming it was done for fraud to avoid paying their creditors, because that everybody should know that these are multi-million-dollar claims on a death case, and there was only $1 million worth of coverage of insurance and blah blah blah. That's a real life case. That case ended up getting resolved after about a year and a half. But the moral of the story is that the statute can be used for very odd purposes. And it was a very expensive case to defend without insurance money, to defend the wife in this particular case. But it also goes back to, if you get with your lawyer and your CPA and your insurance guy in advance when you're going up in the world and starting to accumulate assets and liabilities, you can structure yourself properly that this could have been avoided to begin with. That's an example. One other example where this statute has been used recently is you have principals in an LLC, that LLC is being sued for $18 million on a bank note, secured by a real estate mortgage, and of course the value of the property isn't worth the amount of the debt. I mean, hello, how many times have we heard that story in the last 4 years? And where the lender decided, well, we're not going after the collateral because, it ain't going to be worth it. We're going to go sue these guarantors and get judgments against them. We'll just let the collateral sit out there for a time. We'll see how we can gather up assets after we get our judgment. But while the case is going on, that some of these principals who have multiple holdings of all different kinds of interests in LLCs and corporations and land and what have you, through the ordinary course of business, they're just selling their different things. I mean, nothing fraudulent about it at all. The lender, 18 months into this lawsuit, finds out, because they go do the same type thing, public record search, find out about all these asset transfers. They file an amended complaint. This is the same case that they filed against the guarantors. They turn around and file an amended complaint in court, and they now add 22 other defendants. Those other defendants are buyers of real estate. That's what they were, all buyers of real estate. And the allegations are that y'all bought this property and you knew that they were involved in this litigation and it was done and you didn't get, fair market value consideration and blah, blah, blah. Well, all these people get served. Somebody shows up, the sheriff shows up on the door and serves them, wherever they may live with this paper. And of course, these buyers, have no idea what's going on. And I end up representing two different sets of those. And we end up getting the case dismissed against them because I threatened their lawyers under certain type of procedures that I had to put together affidavits, all the documents and what have you, put them on notice that you ain't got no, if you have any grounds for this, you better be showing it now, otherwise we're going to be seeking attorney's fees against your firm and your client, bank, because these are just good faith purchasers of property. But the bottom line is these clients they have to spend $2,500, because they got to pay us to gather all these documents, put all this together. And again, in this particular case, I think this statute was abused by this plaintiff law firm out of Orlando, these big shots down there. But it's the kind of thing that I'm trying to tell you is another reason why you should plan in advance so you can avoid having to deal with law firms that try to use this as a tool.
So, as Dana was saying, it's hard nobody's going to just stand up in court and when given the opportunity to say, yes, I intended to make these transfers to defraud people. That doesn't happen. So what the statutes look at is, what are the things that would make it look like that we can infer that there's a fraudulent transfer? One would be a transfer to an insider. That means somebody that you're related to, okay? Whether you really didn't make a transfer, you still retain possession or control after the transfer. So I'm transferring to somebody, but I'm going to stay on the property. If the transfers, whether it's disclosed, everybody knows about it, or whether it's concealed, I don't tell anybody that I gave my brother all my assets. And whether before the transfer that there was a lawsuit threatened Whether it's a transfer of substantially all of my assets. If I still have enough assets to satisfy the claim, that would be an indication that transfer probably wasn't made to defraud a creditor. Whether I leave, I abscond. Whether I'm removing or concealing assets, again, this is the big one, whether the value that I receive is reasonably equivalent to the value transferred. That's a huge fact issue in many cases. I mean, who knows what real estate's valued at, at any given point in time anymore. Whether, as a result of the transfer, the debtor becomes insolvent or was insolvent at the time the transfer was made, and whether I incurred substantial debt before or shortly after the transfer. All right. So here's the problems that come up. When an individual who transfers to an insider, not even knowing that you have, and they brought home a practical example of that, not even knowing that he has a possible creditor, okay? You face the possibility that that transfer can be set aside. There's an unlimited period of time in which a plaintiff can assert a claim that the transfer was intended to, in part, hinder or delay some person, which is language pulled directly from the statute, and that it isn't even necessary for the creditor to prove intent when the transfer was made. Okay, so what do we do to plan for this? There's quite a few exemptions, areas where you can invest and or be protected. The wage exemption is something I get asked all the time. Can my wages be garnished? Well, the simple answer is that if you do not agree to have your wages garnished, and read your bank documents, because you can agree to have your wages garnished. But if you do not agree to that, in other words, in writing, like at the time that you assume the debt, then your wages cannot be garnished. And for those of us, even if you have agreed to have your wages garnished, you're protected up to $750 a week if you are a head of a family. So the key is, don't agree to let your wages be garnished, because then they won't be garnished. Life insurance and annuities. You're going to see a common theme throughout this, which is life insurance, and the insurance industry in general has some of the most powerful lobbyists because they've got really favorable treatment under these things. The cash value of life insurance policies and the death benefits from life insurance are not subject to creditor attack. So I could have $100,000 worth of cash value in a life insurance policy, and that would not be subject to creditor attack. When I die, the proceeds from that policy getting paid to somebody else are not subject to creditor attack. Yes.
What if you bought a life insurance policy that had a high cash value, subsequent? I mean, you knew you were getting sued, and you put $500,000 or whatever into a life of that type. Would that be a fraudulent transfer?
Well, if you could prove the intent was to hinder, delay, or defraud in that particular instance, yes. And so that's another crux to all this is the underlying transaction. You're going to see we can do a lot of planning, but if the reason for doing that was to hinder, delay, or defraud a creditor, then that would be a problem. You couldn't go out, there's a judgment against me, I have $500,000 in an individual bank account, and I go buy a policy, a single pay premium policy for $500,000. That wouldn't be a good transfer.
However,
thanks for thinking that way.
That's a great question, but and I'll talk about it more at the end when John finishes, but if you look at all the circumstances and you make it part of some estate planning, the idea is you find yourself in this bad situation, it doesn't mean there's no answer. It just means there's certain business risk tolerances that you have to be willing to accept. Mm-hmm. And so, and we'll talk about that because it really is, you have to look at the whole picture.
Another area of life insurance product that has that same benefit is annuities. An annuity is where you're paying a premium to an entity that is going to pay you an income stream over years. Those are protected, the income stream as well as the cash value of that annuity. And then I'm just referencing a Supreme Court case that addresses that issue. IRAs and retirement plans. The money that you have in your IRAs are protected. And the concept behind that is that an IRA is a relationship that you have, the person, the plan administrator for your retirement plan, your IRA, is a trustee. And that means that you don't technically have control over that money. So therefore it's not treated as yours. And also, it advances the very important public policy of we encourage people to save for retirement. So that's why that money is exempt from creditor attack. Similarly, 529 plans, I'm going to back up on that for just one second. You have to be careful though, if you have an IRA that you're in complete control over, it can be self-directed as to investment, but if there's different plans, different retirement concepts that you can come up with that you really kind of defeat the whole trustee concept and putting the money in the hands of a third party that has an obligation to give it to you when you ask for it, but also that there's a tax deferred benefit to it until you reach a certain age. So you get that one is a great program, but when you get too creative on the retirement fund itself, you may run into some issues. And finally, 529 plans, educational savings plans, health savings accounts, medical savings accounts, educational RAs, and believe it or not, hurricane savings account. Do any of y'all know what hurricane savings account is? Hurricane savings account is where you set aside a particular account to pay for the deductible on, as y'all are aware, if you live on the coast, you get a 2% deductible on your coverage. And so if you put aside hard cash funds for that, that's also exempt from creditor attack. Okay, so those are some exemptions. This is a big exemption. And in the first scenario that Dana had given about the couple, if that gentleman who was involved in the automobile accident had, instead of having property titled in his individual name, had titled it in he and his wife's names as tenants by the entirety, wouldn't have faced any of those claims, because that property, tenancy by the entirety property, which is only available to a husband and wife, and while it's not unique to the state of Florida, there are other states that have it. There's many, many states, the vast majority of states do not have this, which is one of the reasons this is a great derivative. Any asset that you acquire after the date of your marriage in the state of Florida, in your names jointly with your spouse, is presumed to be tenancy by the entirety property. And there's several legal consequences of that. That relationship is considered to be so important that the law is not going to allow that unity of relationship to be broken by a creditor. There's rights of survivorship too, so on the death of either spouse, it passes to the other. And that's important. I'm going to get to that in just a second. But in an example where I've obligated myself under this hypothetical to $5 million worth of bank debt, and I've signed on the dotted line for that bank debt. And it was a real estate project. I bought it in 2005. And in 2007, it's worth about $2 million. And I can't service the debt. I can't go forward with it. So I get a judgment against me for $3 million, which is the deficiency between the value of the property and where I'm at. And I, in fact, agree to all that. But I own my assets. I own 15 lots worth $100,000 apiece, jointly with my wife in our joint names as tenants by the entirety. The bank cannot force a partition of those lots to require me to disgorge even half the value of those lots. So very, very, very powerful asset protection planning tool. Now, what's the downside to that? Well, my wife dies. Because guess what happens? By operation law, that property passes directly to me. I now have 15 lots in my individual name worth $1.5 million total, 100,000 apiece, and that's subject to attachment by the bank. So that's the downside to it. Are there ways to plan around that? Absolutely, yes, sir.
What happens in the case of divorce? Do those lots become on tenants, joint tenancy then instead of tenancy by the entirety?
Well, the court's going to make an allocation of the assets of the parties, an equitable distribution of those assets. Usually, as soon as the divorce takes place, whether there's a conveyance or not between the parties, and usually one party would end up with 7.5 lots and the other one with 7.5 lots. But once that marriage is terminated, that unity in relationship is severed, and they would be tenants in common at that point, and that would be severed. That's another good point. I mean, tenancy, we bandy about these terms in the legal profession, but tenancy in common just means that Dana and I, we're not related by marriage, obviously. We buy a lot
I
together.
don't know, I feel that way.
And then I get that judgment against me. The court, the plaintiff's counsel for the creditor could force the partition of that property, which usually means the sale of that property, and half the proceeds from it would go to satisfy my debts. Dana couldn't do anything to argue against that.
I'd either have to pay off his half to the bank and work it out, or it gets sold to public sale.
Okay, so tenancy by the entirety. If you leave here with nothing else today, tenancy by the entirety, retirement accounts, life insurance, annuities, these are areas where you can protect assets. Tenancy by the entirety is very, very important. What could have happened under that first hypothetical, if that tenancy by the entirety relationship had existed instead of the individual owning that property in his individual name, there could have been a transfer of that exempt assets to the former, what was going to be the former wife, and it wouldn't have been subject to any fraudulent transfers laws because it was an exempt asset to start with. Okay. Another concept is homestead, and homestead is protected constitutionally from creditor attack. Y'all may remember there was a famous case about a former baseball commissioner who moved down here from New York after his law firm. He left being the baseball commissioner, and his law firm went bankrupt. He bought a $10 million house somewhere down in Merritt Island or West Palm or someplace like that, and declared bankruptcy shortly thereafter. The entire value of that property was protected from his creditor's claims. They couldn't touch it. Because in Florida, your homestead is protected under the public policy that we're not going to throw people out of their homes for debts unrelated to the actual homestead itself. Now, it doesn't mean you can go out and buy a homestead, owe the bank, on the homestead, and then not pay that bank debt because they've got a secured interest through their mortgage in that property. Okay. Homestead is limited to 160 acres if you're outside of a municipality, or within a municipality, 1/2 an acre. And that causes all kinds of interesting fact patterns when people have 172 acres outside a municipality or 3/4 of an acre, in a gated community. What happens as far as it being protected?
What happens when you're outside a municipality and you're like right on the edge and the town grows and you get included in? Does the grandfather you or?
Yes,
Okay.
you're protected. Now, it doesn't make any difference what the value of that property is. It can be, like under my hypothetical, or the real fact pattern, it was over $10 million. Significant protection. Okay, and that exemption in yours, which means it goes to the benefit of the surviving spouse or heirs. So when that property is sold, it's not subject to creditor's attack. I have a homestead, and I have children, and I have that $5 million judgment I'm talking about, and I die. If it was my homestead, that $5 million would pass on to my heirs without the creditors having an opportunity to get it. Okay? Very, very powerful.
Is there a phase in as far as time is concerned? In other words,
Yes, there is. And that really comes under the bankruptcy laws, and it's 1,215 days. And there's also limitations under bankruptcy now. But that's only the super creditor, which of the government and the bankruptcy trustee under the auspices of the government that gives you those situations. So you don't want to, if you're being attacked by creditors, you wouldn't want to substitute homesteads necessarily without talking to a lawyer first to make sure you're doing it in a proper way.
Because right now, because of some of these cases that came about with the bankruptcy law changes, I'm not a bankruptcy lawyer either, but I work with a bunch of them, that if you filed for bankruptcy, you would have had to own your homestead for over 1,215 days or longer to have it totally protected. If you did not, then you only get a $125,000 equity exemption. So huge difference. Now that doesn't mean you can't sell a homestead and reinvest in another one within a certain period of time and all that. But these are definitely things that you need to consider if you're trying to use monies to buy a homestead, maybe a larger, more expensive homestead, and try to avoid creditors.
We talked about business entities. This is now going to, you're not an exempt asset, but how can you structure assets so that the interests themselves are statutorily protected? And in business entities and limited liability companies in particular, you have a membership interest. And you can contractually have a relationship with the other people who have membership interests in that entity to almost like a poison pill provision, to make it very untenable for a creditor to want to assume the position of that membership. Also, you can, but statutorily, a creditor is limited to what's called a charging order, which means that instead of being able to force the sale of the membership interest, which is what you can do with stock. If I know somebody's got stock in a company and I'm a creditor's lawyer, I can actually seize that stock and have a sale of that. If it's publicly traded, I just publicly trade it on the exchange. Or I can have a court-ordered sale of it. With a membership interest, I don't have that opportunity. I can only receive whatever the member would have received. And the public policy behind it is that limited liability company members are analogous to partners, and the relationship of partners is a much more personal relationship than that of stockholders in a corporation. So that's the rationale behind it. Single member LLCs and sole shareholder corporations are a potential exception to that because of the control issue. If I'm the only member of an LLC, I don't have that partner relationship, okay? So you would always want to create an entity that has at least one partner, so you can avail yourself of these arrangements.
If I may, on that one issue, there was a Florida Supreme Court case earlier this year that, I think it was earlier this year in February, March, which addressed this issue of single member LLCs. But the case was, you have, I think it was some federal agency, Uniform Commerce Commission or something, the Trade Commission, that's what it was, FTC, had gone after this group of these guys in Florida that were running some scam operations. They ended up getting a judgment against them in Kentucky for, I don't know, $3 million, I think it was, something like that. And then FTC came to Florida and they went to levy on the membership interest of this particular principal, this particular guy that owned several LLCs, and those LLCs just happened to own a bunch of real estate and bank accounts and other things throughout Florida. And of course, the defense is that, wait a second, we have a charging lien statute in Florida. We have a very strict, statutory scheme. You can't, grab the membership interest and go liquidate the company. All you're entitled to do is get a charging lien. Well, the 11th Circuit Court of Appeals sent that to the Florida Supreme Court because that issue had never been addressed as it came up in this particular fact pattern, and the Florida Supreme Court said, no, if you're a single member asset or single member LLC, your membership interest, despite your statutory scheme, can be levied against by a creditor so they can take hold of the company and liquidate its assets to pay the creditor debt. What's interesting is when you read this 30-page opinion that is really all over the board, convoluted opinion, but the bottom line is they infer in some respects that we're only addressing single member LLCs here. We're not addressing multi-members. But if you read their analysis on how they got there, if you don't have if your clients or people that you know or yourselves have multi-member LLCs and you don't have a written operating agreement, a regulation or partnership agreement that specifically adopts the Florida statutory scheme of charging lien only for creditors, in my opinion, that there will be a case that will come down at some point in time because the Supreme Court, using that same analysis, they can bust it. In my opinion, they can be able to bust a member's interest. Now, would a creditor want to do that? If they're also assuming the tax liabilities that they had known nothing about in that particular member, who knows? But bottom line is, it made everybody aware, lawyers that work in this field, that you ought to be able to make sure that your people that you know or yourself, if you're involved in a partnership of any kind, general partnership, LLC, limited liability partnership, I don't care what it is, you better have a written agreement, and you better met with your lawyer and your CPA and make sure you understand every aspect of what that agreement says, because you'll rule the day that you didn't do that if there's some issue comes about.
In that operating agreement, you can also have provisions that relate to what we call involuntary transfers, death, disability, bankruptcy, creditor attack. And you can contract to have values for that and restrictions on the rights. So you can, in that hypothetical where a creditor is trying to attach a membership interest, you can make it where a new member can only be admitted with the unanimous consent of the other members, that a new member can only be admitted as a non-voting member, that a new member can never have any management authority. So there's different things that you can do if you draft the documentation properly to make it very unattractive for a creditor to step into the shoes of the member. Okay, some other opportunities. People can receive beneficial interest from trusts. So if I have judgments against me, but I don't control the flow of the money to me, the creditor is not going to be able to get the money before it gets to me. Now, once that money's in my hands, they can get it in my bank account. But if I have had the foresight, or if I had a parent or a brother or some friend that had the foresight to create what's called a beneficiary trust or beneficiary, and there can be some nuance to that, where the debtor can actually be an advisor to the trust about uncertain things, as long as it doesn't relate to distributions from the trust. You can structure things in such a way that the bulk of the assets are not subject to creditor attack. So, and that's through what's commonly known as a spendthrift provision, which says that my beneficial interest in that trust is not subject to the creditor's claims, and that's perfectly valid. Now, we get back to the funding issue, which Buzz was talking about earlier. Then that could be a problem. If I'm the one that's putting all the money in the trust, then it can be an issue. But if I've set this structure up and I've had the foresight to do this, I can literally make myself judgment proof. Okay. And that's the funding issues I was just talking about. Another interesting nuance that's available, and why you have to have somebody that has scoured the different states' opportunities. The state of Delaware has an absolute statutory prohibition on garnishment of residents' bank accounts. What does that mean? If I'm a Delaware resident, I've got $5 million in a bank account. It's not subject to any creditor's attack. Well, it doesn't work that way in Florida. It doesn't work that way in most of the other. But that's a very powerful tool. And there's ways that you can combine strategies to be able to avail yourself of that, but they're fairly complex.
You don't have to live there. We figured out different ways that you can create entities who become residents by the residence domiciliary status in Delaware. So,
A Delaware LLC, for example, it would be considered a Delaware resident. Okay. Everybody always asks me whenever I have any of these opportunities for presentation is, oh, what about offshore trusts? I've always heard these offshore trusts are the best thing ever. You know, the Isle of Man and the Cayman Islands and all. No, doesn't work that way. Y'all have actually seen, it's been in the press a lot recently about people that had banking relationships in Switzerland, and how the U.S. and the IRS in particular has been very interested in breaking through the secrecy rules of those, and successful in doing that. UBS is turning over client lists. And very, very powerful thing. Well, the advantage to doing anything offshore, and there's a lot of complications to it, but the advantage to it is to create, from a creditor protection viewpoint, is to create jurisdictional issues. The Isle of Man doesn't pay any attention to what the United States Supreme Court says. They don't care about that. But with most countries, in fact, the United States has had the foresight and to enter into treaty relationships with them where they do give certain authority to them. So don't think that an offshore trust is going to be the solution to creditor protection issues, because the same statutory Fraudulent Transfer Act provisions are going to allow a creditor to get to those assets but it's going to take a lot more time and money. So there's some, it's one of those quid pro quo kind of things. You get what you pay for sometimes, but some things are inevitable. So don't think of it as a panacea. And for goodness sakes, don't be one of these people that think you're going to hide assets offshore from the federal government, because that is absolutely the worst thing you can do. There was a period of time 15 years ago where people are all running around town and they had credit cards from, the Isle of Man or something. Well, and they're thinking that all those investments and the earnings on those investments are safe from the Internal Revenue Service. They're not, they shouldn't be, and you'll go to jail for it. So, okay. So to just conclude, because I see we're running out of time here, maintain your residence and domicile in the state of Florida because it's the best state to be a debtor. File a declaration of domicile. Have your voter registration here, driver's license, maintenance, or bank accounts. If you have parents or if you are a parent, it's a great idea to structure either what you're receiving or what you're giving to the beneficiary in trust and have the spend-through provision. If you have a child, and I know people say, I don't want to control things from the grave, but if you set up a trust that has a spend-through provision and that child falls asleep at the wheel after being up for 72 hours because they've been studying for their medical exams, go off the road and they kill somebody who just happens to be in his third-year residency at Harvard Medical School worth about $100 million in future earnings, what's in the trust is not going to be subject to attack by that resident doctor's estate. So trust can be a very effective way to plan, but it's always forward thinking, okay? Invest your disposable income in an annuity product. It's exempt, or life insurance. Hold your home and other real estate and other accounts in tenancy by the entireties. If you take nothing else away, take that away. And buy a life insurance policy paid in trust for the benefit of the family. Contribute to the 529 plans and these other, like the health savings accounts, MSAs, a hurricane savings account. Those are all exempt. So that concludes the formal presentation. We probably have like 120 seconds for questions and then
We have more than that. We have as much time as anybody
Yeah.
wants to stay, that
Sure.
we're here to talk. I want to say some things in parting. 5 years ago, I mean, you had some lawyers who did some estate planning, but most people didn't think about it because you really, I mean, we've been in a boom economy here. All you guys and gals that lived here, you've seen what's happened. I mean, really since the mid-90s. I mean, we've been growing, and then all of a sudden, we have this major catastrophe that takes place. And it's not just here, it's all over the country, and I'm not going to get into all that. But the bottom line, as lawyers, and I've been doing this almost 30 years now, as lawyers, we've never had to deal with people and our citizens, our public, our neighbors, being in the situation that they find themselves in. People that would never, and all y'all are in this room are the same as that, nobody would ever consider not paying their home mortgage. Nobody would ever consider not paying their banks or their bills. It's a foreign concept. Life has changed. It's not that way anymore. I mean, and we face, I cannot tell you how many hundreds and hundreds of people that we've dealt with in the last 5 years that find themselves in situations that they have no idea. And as lawyers, we hadn't been spending time over the previous 25 years working on it because it just didn't happen. It didn't exist. And so we find ourselves trying to help our clients aptly propose, wolves at the door, how do you keep what you got? What John was going through with you was the law and the ideal world and things that you need to know and you need to think about for yourselves and your friends and people that business acquaintances you work with, because there is going to be another day, and we're not going to be broke forever, and there's going to be prosperity, and we live in one of the greatest places in the world right here, that there's a lot of money to be made in the next 20, 30 years in this area, in my opinion. But for those who find themselves upside down and did not do this proper planning, that doesn't mean it's the end of the day. There's all kinds of legal strategies that can be used to deal with your assets, that I can't wave a magic wand. Once you find yourself in the situation of you're upside down, or you got that, or you're being sued, I can't just wave a magic wand and take all your assets and put them over here and say, okay, you're protected. But there's a lot of things that good lawyers can do working with the accountants, because you always got to take in consideration the tax consequences and how that all works, and the estate planning aspects, and you look at everything as a whole, and you talk to your clients, we talk to our clients on business risk analysis. Because at the end of the day, ain't no 100% guarantee, but there's a lot of things that we can do to put up enough roadblocks that maybe that creditor at the end of the day ain't gonna be chasing you. And trust me, chasing a judgment, what most of these banks, and I'm talking about banks primarily, that's what we're all saying, you know, most of these banks and credit card companies and financial institutions that are suing and they're getting their judgments, their lawyers that get those judgments have no idea how to collect on those judgments because that's not what they're trained to do. They have contracts with these big law firms and they go and they know how to file foreclosures and they know how to get judgment. But then what happens? Well, it's just a piece of paper if they can't collect on it. And then, and there's not a lot of lawyers that do this collection work. And there's a lot of things you can do to put so many roadblocks in the way that they're going to get frustrated or they're not even going to pursue it. And you can structure yourself properly, or at least within a business risk tolerance that you might be willing to accept. And I tell you that only because that even though there's no, like I said, no magic wand, but every person that finds himself, or you know people, they really need to sit down with their lawyer and their CPA. And the lawyer and CPA can't be just talking one and then the other. Those guys not. I mean, this is a collective decision making because you got to understand as a lawyer that person's entire personal and financial portfolio, so that you can help them and because their strategies are different for different people. So I just wanted to share that with you because when I do a lot of litigation besides transactional work, and every case is different, and all the facts and different lawyers that you're involved in, they're not all the same. And I hate to say it, but it is what it is. A good lawyer is going to be the bad lawyer every day in court. That's a bad byproduct of our system, legal system. But good lawyers typically do well for their